are processed. So whenever we have a complaint that's processed, the complaints are no different than a regular lawsuit that is filed. Typically, people don't put statutes, express statutes in a complaint that is filed. They generally plead what they believe to be the case, which a lot of times happens in these election law complaints because you're dealing with people that don't necessarily understand election law or even know what statutes apply. So when there is a complaint that is filed, those complaints are processed first through the administration. The administrative staff looks at those. They refer those to Attorney Brandenburg and myself. Then Attorney Brandenburg and myself, we go through the complaints and we decide whether or not there is enough to rise to the to an election law violation. Is there enough evidence where it needs to be set for a hearing? That process was followed here. So when it goes to the election board, there is technically no specific statute that is in mind other than generally looking to see if there is an election law violation. It could be a number of statutes, which is what was the case here. So electioneering was an issue that the board considered and that Attorney Brandenburg and myself talked about and considered, but also the obstruction statute was also something that was considered. And again, I want to make very clear, I have no dog in the fight. I give legal advice. I don't give Democrat legal advice or Republican legal advice. I give legal advice. And that's what I was asked to do. So when we looked at these statutes and looked at the facts, we talked about both. We didn't just talk about one. And if you look at the minutes, it's been raised a number of times, both statutes, not just the electioneering, but both statutes. So when people are called in, they are called in to answer for all charges that could potentially be out there. And I think what happened here is I think Jessica might have attached the statute, but that was more of a helpful hint for the board, but that typically does not happen. I know Leanne and Michelle typically don't attach statutes, so I think that was more of a helpful hint for the board, which I appreciate, but I don't think that framed or closed the issues for the board to consider, which they considered for the last 3 or 4 meetings. It's been both statutes, not one.
Thank you, Mr. Tolbert.
Mr. Chairman, is there anywhere that shows that because I agree with Mr. Tolbert that, individuals maybe don't have the expertise to know exactly which election law they're filing a complaint against, but when the staff and the attorneys look at it, I'm sure there's some level of documentation that shows what the potential violation of election law is. Now, on our agenda, item 7, it listed the electioneering statute. It didn't talk anything about obstruction. So if we subpoenaed individuals, we asked them to come in for a potential violation based on electioneering, but we didn't inform them that it's based also on obstruction, I think that those individuals should have the time to prepare themselves properly to be able to get witnesses, to be able to do subpoenas themselves, to be able to get information, to be able to defend themselves properly, or to at least make their argument that there was obstruction.
I'm not sure. I'm sorry.
From what I recall from the conversation, I even asked the individual if she was obstructed from doing her job, and she said she was upset. She didn't say that she was obstructed from doing her job, but that's all things that we can hash out later. But right now, I'd love to see a document that said that our staff and our legal experts went through and these were the potential violations of election law, because the only thing I've seen written anywhere, and maybe I've missed it, and it's possible I've missed things before, made a mistake back once in '82, sorry.
Not forgetting about 86.
Yeah, 86. Yeah, that was right. No, but the only thing I've seen so far is based on electioneering. And I don't think it's fair to bring 2 parties in to argue electioneering when they're not even aware that electioneering was a potential violation.
You mean obstruction?
I'm sorry, obstruction. Yeah.
Well, I think a couple of things. I'll just comment on that. And what we've heard from our attorneys is that I think you just pointed out something that's important, is that you actually questioned the witnesses about obstruction because we had started going in that direction, or that statute was brought up during the hearing.
Yes.
And so I think that it's pretty obvious to me from the record that the evidence was presented, I know, by the officer, Mr. Allende, regarding whether or not whether or not in his mind he knew Mr. Justice was an election officer. So I felt that we gave all parties a very thorough ability to address the board on what happened that day. Now, I can't recall a situation where we've said, oh, we heard everything, and because now we're looking at this statute or that statute or that statute, we're going to, reopen everything. It was a situation where I gave every party an opportunity to both cross-examine, for lack of a better term, we'll call it cross-examine, and issue any additional evidence they had on that day. I think both parties said, nope, this is everything. And during the evidence when they were presenting I'll say everything, there were questions, as you pointed out, Mr. Mellon, about obstruction. And so I don't agree with the let's reopen it for purposes of presenting more evidence, because to me, we closed it. And we don't, this is not a judicial body. We operate under the election board statute. And to me, I think it'd be like beating a dead horse at this point. We've heard everything. Yes, Ms. Brand, no, go right ahead, Ms. Brandenburg.
I think that there's probably a couple ways the board could go today. I don't think there's anything at all wrong, and I didn't mean to suggest in my comments that the board reopen this matter or even set it for another hearing. What I'm suggesting is that if you want to get additional legal analysis on the intentionality, the knowing aspects of this provision, Mr. Tolbert and I could provide that now. I've done some additional analysis and digging. We can do that. If, however, because of a couple of unique circumstances that were involved in this particular instance, the board is potentially inclined to move forward with a prosecutorial referral under the obstruction statute, my recommendation would be to take a more measured approach and provide additional opportunity for rehearing on that topic only, simply because this particular complaint was continued multiple times. I know when I analyzed it as an attorney, the only statute I flagged as a potential violation was the electioneering statute. The obstruction statute evolved over the course of a couple of different hearings, a couple of different board meetings. I'm sorry, I shouldn't say hearing, board meetings. There was discussion at board meetings, but it was never really analyzed. And it was discussed, and yes, it was considered in the testimony and the hearing, certainly, but that doesn't necessarily mean that the parties might not have wished to provide additional investigation, present additional testimony, such as, for instance, the other poll worker who was present, who asked Officer Alande to cover his shirt up, and he immediately did so, having recognized her as a poll worker. So that would be something that, just to take a more cautious approach, if the board is inclined in that direction, I think would be, I would advise in that direction. But again, happy to provide advice just as to the knowing analysis.
Just a quick question. Quick question for you, Ms. Brandenburg. So one, I think that the testimony, and again, we take hearsay testimony, right? We've done that always. So the testimony from, I think it was either Mr. Allende or maybe his counsel regarding the what had happened with the other election worker, I think that weighed into whether or not the board dismissed the electioneering complaint, because I think that was important information that we learned. I don't recall, you referenced that there were prior board meetings where we talked about obstruction. If you want to help me remember that, I would appreciate it. I just remember really it getting continued, and then we heard it.
Well, it was continued a couple of times because the parties were not present.
Right.
And at the meeting prior to the meeting at which the hearing actually took place, which I cannot recall the date, but I suppose that would have been, what, February?
March, whatever,
Yeah.
April, whatever. Okay.
There was some discussion about obstruction with voters, and the term used in the minutes was actually voters. It wasn't specifically analyzed in the context of this statute, but I believe that because that was mentioned, it ended up evolving again in the course of the hearing at which Officer Alande was.
So there was a discussion about it? There's an actual discussion? No.
No.
It was just, there's some reference to it.
I know as counsel for the board, I did not analyze the obstruction statute until that hearing date and that meeting date at which the hearing was held.
Well, the question I have is I don't understand that because it was in the minutes prior.
It was not specifically referenced, and it was referenced in terms of voters.
I disagree with that, but I guess my opinion is I agree with the attorney Brandenburg from the perspective of if we want to be extra cautious and safe, if you want to set it for another hearing to get more information and to allow more attorney analysis, you can never be too safe is kind of my opinion on these things, especially when you have a pending FOIA request and some of the allegations that have been made, I believe by Attorney Viss, there could be a potential for litigation. So if the board wants to be extra special cautious and make sure that you have a sound, accurate legal opinion, I have no problem going down that road. In terms of having another hearing, my only concern is for the purported victim in this case, who has already come forward once already. And if I recall from the hearing that we had, she was extremely shaken. And, it sounds like she's probably not going to come back.
Well,
So you have to consider that, I would say. I don't think we should victim be either by having her come back and have to tell the same story when she's already given it once.
Yeah,
I don't think that's fair.
I'm not as concerned about that. I'm more concerned about the fact that my recollection is, and I'm going to let Clerk Brown, I apologize. I just want to finish my thought on what Mr. Tolbert said. My recollection is that I basically told both parties, hey, we're done. You don't have to come back again. If you want to come back, you're welcome to come back, but we're done as far as taking evidence is concerned. That's the way I believe I left it. I don't have the minutes in front of me, but Clerk Brown, you had something you wanted.
Thank you, Mr. Chair. My concern was the amount of time that the gentleman had received notification. He did not come. There's no question about it. But at no time did we take any action or do anything officially regarding the case. Anything that might have been said to me, in my opinion, might have been somewhat of hearsay, because we didn't officially go on the record until he appeared with his attorney and the other young lady. So from my standpoint, there was nothing official about that until we actually had the hearing. And I think that's really what the issue is right here. We've had a hearing. We have done our due diligence as far as getting the information out. So I generally don't have an issue with your legal opinion, and I still don't. But I must tell you my opinion as a board member, sitting here for all those meetings and seeing that the gentleman took some time to get here. And when he got here, he had his day. And I believe that he had his opportunity. So.
Well, Ms. Justice did not show up to any meetings prior to that last meeting either. Just
Agreed.
Yeah, that's what we're saying.
Yeah.
That's my point.
I think we tried to get everybody here.
Right.
Yes, that's my point. He didn't. So there.
No, but neither did she. The
But I
person who
understand.
filed the complaint didn't show up for 2 meetings either.
I understand, but my point is we did not act in any way on the case prior to both parties showing up here. So anything that might have been just said in general to me is no different when what the weather is, the temperature, because it had nothing to do with nothing.
That's part of why I raised that, is that I don't think there was any analysis of additional statutes beyond actual electioneering. Certainly not that was flagged for my analysis to discuss at that hearing.
So I guess what my question to the attorneys would be, because we've heard from.
Mr. Chair,
I'm sorry, Mr. Fenn.
obviously I'm the new guy sitting here as proxy, but to Mr. Tolbert's point about notice pleading in the state of Indiana, I don't think that anybody could read this transcript and not think that the issues that were before the board were electioneering and interference and obstruction of an election worker. I mean, simply when the evidence was presented, Mr. Viss had the opportunity to cross-examine Ms. Joss and question his client. He addressed both of the issues in terms of the electioneering as well as the interference. and obstruction. And really, he attempted to go to the point of whether or not it was knowing and intelligent in terms of the obstruction, whether or not he knew Ms. Joss was an election worker. And so I think that it's a notice pleading type situation. And I think that the board could have taken up the electioneering aspect as well as the obstruction.
All right, thank you. So I guess where we left it, is that,
Mr. Chairman.
I'm sorry, Mr. Reed.
Since everybody else got to go.
Yes.
I just feel left out. No, I appreciate what Mr. Tolbert said and what Ms. Brandenburg said. And, you know, I wouldn't mind seeing a little more legal analysis on it before, you know, any decisions are made or referrals are made. But I'm also a little bit curious, and I don't, you know, I understand the point of not wanting to bring the young lady back here and, you know, question her again and go through it. I think we've heard her say everything she has to say. There were also 4 other poll workers there. I'm kind of curious what their take is. Haven't heard anything from any of them. That's not uncommon for us to have more than one, you know, poll worker, judge, inspector show up at a meeting. I'm kind of curious what the temperature was in the room at that time and how, you know, if we're talking about obstruction or interference with a poll worker doing their duties, you know, for how long was Ms. Justice not able to conduct her duties? Was it 10 seconds, 30 seconds? Was she in a corner upset for 45 minutes? I don't know. But I think that might be relevant. But I do want to point out too that, yes, Officer Lande was here and his attorney was here. And I think his attorney was here having read the complaint. And the center of the complaint is Trump Make America Great Again t-shirt. But smacks of electioneering. And to think of the idea of taking, you know, Section 3 of the Indiana Code and saying, I'm going to read all 600 of these code sections and try to decide which 400 might apply to this case. I think that's a tough day to come to court, have not court, but quasi judicial proceeding and ask myself, what am I defending my client against?
Thank you, Mr. Reed. I guess, yeah, I mean, just personally, I mean, I don't want to necessarily get too far and weighing into this because I do have a question for our attorneys. But like, to me, it really focused on his behavior in the shoot towards the election worker. That's how I always looked at it. I didn't think of it as, because to me, I was always the fact that he eventually turned it inside out, I think, you know, weighed in on my decision on the electioneering complaint. I was most upset about his behavior in the shoot, honestly, and about how he acted with his badge and how he reacted to, you know, what are you going to do about it? Go ahead and call the police. I am the police. That to me is what I was most concerned about. And I think actually, if you look back at the minutes and prior meetings, I think that's where, when we had brief discussions about the allegations, that's what others were on this board were concerned about.
Mr. Chairman.
Mr. Mellon.
And if the gentleman was a jerk, I don't know that that's obstruction of someone's job.
It's a fair point.
And that's one of the problems I'm having here is because I'm not going to disagree with you that he was a jerk. Okay, that he behaved, and he probably even regrets his behavior. I think he even said he regretted his behavior. I think he even apologized to her for behavior. So what we're dealing with here is an obstruction violation, which is a referral to the prosecutor. And I think that has to have some level of evidence that's beyond somebody just being a jerk. Because if we're in a society now where just being a jerk is now a violation of law. I mean, I'm looking at this room right now, and most of you have a law violation against me, in all honesty, because I've been a jerk to most of you at one point in my life. So, Mr. Chairman, I mean, being the most consistent senior member of this board, I always go by precedent. And typically what we do is when something is framed, and this was framed as an electioneering violation. Now, within the process, we brought up the obstruction, and there was ample discussion on that. But prior to that, there was not a lot of discussion on that, and the complaint was dismissed. And I think that's specifically why you say, and I read here, so there's a motion to take the matter under advisement. Is there a second? So Clerk Brown, I understand you're right. You're asking that the board take the matter under advisement. So I'm on page 116. And that's why it specifically wasn't a continuation, because it was taken under advisement. Now, what that implies to me, based on the precedents and based on the history of this board, is that we may want to do an investigation. And we're going to take it under advisement. We're going to look at some different things. We're going to talk to our attorneys, and we're going to do exactly what Mr. Reed talked about. And we're going to pull other people in to corroborate a claim, which I don't even know that there's a claim of obstruction at this point. This is something that we have manifested based on rude behavior of an individual. So I don't know if the vote is going to, I'm not sure what the direction we're going. You're looking to take a vote on a complaint. I don't know that there's still a complaint out there, quite frankly, but okay, the complaint will be for obstruction. If you're prepared to vote and refer to the prosecutor based on the violation of the obstruction law, I don't think that you have all the evidence to find somebody guilty of that.
And I guess that's why, right, we always tell people, if you don't agree with our decision, you can appeal.
Right.
If we've made error, have at it, right? I mean, we're not perfect here, and I'm not suggesting that's the direction we're going. I'm just saying.
But Mr. Chairman, the problem with that though is that's an easy cop out. But this
really not a cop out.
But this board, if it starts taking that approach to decisions when we don't have evidence and we refer things to the prosecutors, that undermines our authority. It undermines everything that we do here, and then the referral to the prosecutor with absolutely no evidence undermines our credibility of the prosecutor's office.
I mean, and obviously the difference is that whether you feel there's no evidence, let's just say I feel there is evidence. I mean, the fact is that it's not a cop out. I'm just stating that if and I always mention to both parties if they're here, if you feel that we did something that was wrong and you don't agree with it, you have the right to an appeal. Please, ask your attorney to do that, and you can appeal our decision.
So, Mr. Chairman, what did you come into this meeting looking for? You're looking for a motion on what?
Well, what I guess, as a member of the board, what I was looking for was information from our attorneys on whether or not they felt that their review of the obstruction statute would allow them to tell us about the knowing and intentional wording of that portion of the statute. That's what I came in.
And have we got that answer?
I haven't asked that question.
All right,
I thought we would.
Why don't we do
let the board members and the attorneys state? That's where I was going eventually, but we haven't got there yet. And Clerk Brown would like to speak as well.
I yield to.
I'm sorry, Mr. Fetch.
Thank you, Mr. Chairman. I would just indicate that the unrefuted evidence in the case is that he had the Trump Make America Great Again t-shirt on. Mr. Allende admits to wearing it. Ms. Joss says that he was wearing it and asked that he take it off. Her job there was to prevent, or turn it inside out or put a jacket on. Her job there was to prevent electioneering. She was prevented from doing so if you believe her testimony. And so I do believe that the obstruction statute is called for in this particular case. The evidence has led the board
Mr. Chairman.
Mr. Mellon.
I got to respond to this because electioneering, there are a number of voters that walk into places with buttons and shirts and things like that. That has happened for the last 50 years. And what we look for them to do is to comply. He complied with it. He was rude when he did it. There's no question about that.
He didn't comply until after he saw somebody that he was familiar with.
That's okay. He complied.
Well, actually, it was. All
right, hold on. Let's get some order. Mr. Mellon's got the floor. Mr. Mellon has the floor.
But at the same time, he complied with that, and the electioneering complaint was dismissed. That's over. To argue electioneering now is bringing up a complaint that doesn't exist.
He attempted to inhibit her ability to perform her functions as an inspector to prevent electioneering.
Boy, that's a stretch. I got to tell you.
Okay,
I
Mr.
don't
Reed,
think
did
it's
you have
fair at
anything?
all. He had to go to another election worker who he was familiar with, who asked him to turn the.
She didn't identify herself. She didn't identify herself.
She had a badge on. She testified.
He didn't see the badge. He testified he didn't see the badge.
Real quick, because we're not.
I agree with the chairman. And Matt, this is unfair because you weren't here.
Mr.
He
Reed.
did not look at her. He just thought somebody was bothering him. He said, I'm not even going to look. I don't even want to engage in this. It's not fair to you. You read the transcript, but I'm just telling you that's not the way it went down. When he saw someone he knew to be an election worker, he immediately covered it up. And electioneering was dismissed. It was.
And keep in mind, the goal of this board is not to find people, it's not to refer people to the prosecutors, have safe and fair elections. And if we can get individuals to comply on the spot, and I can tell you stories that will spin your head about people who actually did commit obstruction and we dismissed it because they eventually apologized or they complied. This is a unique, we're going down unique charted waters here. We're about to have a discussion on obstruction with somebody who complied with the electioneering, who complied eventually with the requests of the poll workers. I'm fascinated by this.
I mean, I think our job here is to determine whether or not, and if some action rose to a level of a violation of election law. If we believe that it did, then we have the right or an obligation to refer to the prosecutor. We're going to hear from our attorneys. To me, this is a tough one, but I want to hear from our attorneys. So where I was going with this eventually was to ask Ms. Brandenburg and then Mr. Tolbert for whether or not they were able to take a look at 3-14-3-4 as it relates to the knowing and or intentional element of that statute. Yes, Ms.
Would you like me
Brandenburg,
to do
thank
it?
you.
Okay, thank you. I have again looked at this, and I know we discussed the statute at length together in that last meeting. This statute does require knowing obstruction or interference with an election officer in the discharge of the officer's duties. It is a level 6 felony if referred to prosecutor. And in looking at the knowing aspect, I also looked at IC 35-41-22, which analyzes when culpability is in a statute, what that means in terms of that statute. So this is not within Title III. This is assisting just in, if you have knowing, if you have intention, and that's part of the statute, how do you read it?
Right, Title 35 is a criminal code.
Correct. And that states this is a criminal penalty, which makes sense. If there is a kind of culpability that is required for the commission of offense, it is required with respect to every material element of that offense. So that means, as case law has interpreted it, and as is commonly understood when you apply that culpability to every aspect, that Officer Alande would be required to knowingly obstruct with the intent to knowingly obstruct a poll worker in the discharge of her duties. Based on what I heard during the testimony, I do not see any evidence of that occurring. From a standpoint of the testimony from both parties, there was no dispute. Ms. Justice did not dispute that Officer Alande did not look at her. She was not able to know or say if he ever observed her name tag designating her as a poll worker. She is a lovely young woman who could have, as Officer Alande testified, he thought she was a Harris supporter who was ardent in her passion and wanted to potentially embarrass him and make him take his shirt off in public. So when she left to call the election board and get additional advice, which I think we all commended her for doing. She did her job well and appropriately. She stayed calm and cool and collected. She called the election board as she's trained to do. Another poll worker came up, had the discussion with him, explained who she was. He recognized her as both a neighbor and as a poll worker, and he complied, then understanding what it was he was doing wrong. So when I look at that testimony, which was undisputed, and I analyzed the culpability required for the commission of every aspect of the offense, it would be my recommendation that the board dismiss the complaint in full at this time.
All right, thank you. And looking at 35-41-2-2, it indicates that a person engages in conduct knowingly if when he engages in the conduct, he is aware of a high probability he is doing so. That's how I read it. Okay, Mr. Tolbert.
Yeah, so I gave my analysis on this issue before, and I think I expressed to the board that the knowingly element of the statute is probably where you're going to have a little bit of your issue. But before I even go through that part, I want to make sure that the board is aware that if you look at the statute in the book, that is a little bit different from what is in the pocket part. There's been a little bit of a change in the pocket part. It looks like the statute was actually revised and amended in, I want to say, 2024. And if you look at the pocket part, which is also the same version of that statute of 314-34, it's the same version of the statute that's in the pocket part is also on Westlaw. So I wanted to make sure that we had the most up-to-date version of the statute. But the most current version of the code and statute says as follows. It says a person who, with the intent to obstruct or conjunction or interfere with an election worker or voter in the shoot, knowingly or intentionally obstructs or interferes with an election worker in the discharge of the election worker's duty or a voter within the shoot and engages in the obstruction or interference on election day or on a day which voting is permitted to occur before an absentee voter board commits a level 6 felony. So really the two, I guess, mens rea elements that you're looking at is not only knowingly, but looking at intentionally. In the way that I read the statute, it could be either or because of the conjunction or. And I think what we've been focusing on is knowingly, but there's also the component of intentionally. And the testimony that I heard from both parties, from Mr. Alande and also Ms. Justice, it doesn't necessarily deviate much from kind of what Attorney Brandenburg accounted for. The only thing that I would say with respect to that is, if I recall Mr. Alande's testimony, I remember writing this down in my notes, he refused to look up to her as she was actually trying to carry out her job duties. And that was, I guess that was the issue that I had in the analysis of this whole thing, is that you don't necessarily legally get to push yourself into a state of not knowing, which was, I think, the problem. So he intentionally did not look up, intentionally did not refuse to actually acknowledge who was even talking to him. And I also believe is, I don't want to say attorney fetch because he's not an attorney today, but he's always an attorney, but he's a board member today. But as Mr. Fetch pointed out from reading the transcript and based off of my notes, as I recall, is she had on a badge. So you have Mr. Alande not looking up, acknowledging an election worker. You have a badge, and the testimony, I believe, was the only reason that he kind of complied was that his neighbor, there was a neighbor that was actually working the polls that day that was able to kind of calm him down a little bit. So I think the knowingly and intentionally element is, in the civil context, even though, this is more of a criminal issue, even in the criminal context, it's a question for a jury to necessarily decide. And as you, as the board, as the trier of fact here, you're going to have to decide and weigh the credibility of the witnesses that we heard, whether or not Mr. Alande actually did, in fact, not know that this was an election worker, even though she had a badge on and even though he decided not to intentionally look at her. So my position and my opinion on this is that it's extremely, extremely close. I think it can go either way. I think if you referred it, I don't think you wouldn't be wrong if you referred it. I don't think you would be wrong if you didn't refer it. It's really that close of a call because of the knowingly or intentionally component of this. It just all depends on how you weigh the evidence, how you weigh the credibility, and what you think is true versus not true, which is you sit as the trier of fact in this instance. So I would say, I know that's a kind of a waffling opinion, but that's the type of case you have here. It's not a right. I don't think anyone can emphatically say that this doesn't rise to the level of an election law violation, given the facts, because there's enough there to refer it if you really wanted to refer it. But if you didn't refer it, that would be fine too, because I think that you would have justification because of the elements and the testimony if you believe what the people said.
So,
They
Mr. Chairman,
Thank you, Mr. Tolbert. Mr. Brandt, sure, and then Mr. Mellon.
I also want to add another aspect that we looked at after receiving the FOIA request from Mr. Viss was the past history of the last hearing at which the obstruction statute was considered. That was back in 2022. We reviewed the minutes in full, or I know I reviewed the minutes in full from that meeting involving the Barnhart complaint. that was an instance where an individual was wearing a sheriff's jacket as a deputy election commissioner and got into it essentially with Ms. Barnhart. The board's analysis was that there was a fairly extended period in which the deputy election commissioner and Ms. Barnhart were engaging with each other. He was telling her he was going to take her out of the facility. This lasted some time, but ultimately the board's analysis was that the election worker held her own. She was not daunted in her duties that day. She was not effectively obstructed or interfered with effectively, despite the fact that those kind of actions from that individual on the responding end of the complaint might have constituted interference otherwise. So the board ultimately determined that this was a training issue, this was a personality conflict, and therefore that complaint did not get referred to the prosecutor's office. Despite the fact that I think we had some pretty significant video evidence testimony that the board considered that day of a fairly extended interaction with the poll worker and that responding party. So I think, the board, the reason we looked at that was, of course, because the FOIA was requested. It drew that issue to light. It was also because the issue was discussed during the hearing. And I know during that hearing, the board was very concerned with past precedent. How do we typically look at electioneering complaints? How do we typically respond to those? How do we typically look at other kinds of complaints when they arise? And I think the board is very appropriately concerned with consistency, and I appreciate that. So I do want to bring that to light as well. And I also just want to reiterate that the statute itself says that the person has to have the intent to instruct or interfere with an election worker. The intent must be to obstruct or interfere.
Thank you, Mr. Mellon.
So, Mr. Chairman, I just comment to Mr. Tolbert's comments. I still don't know what the obstruction was. I mean, if we're going to now say that any voter that comes into the polling place that argues and doesn't immediately follow the instructions specifically of any poll worker, that person is in violation of obstruction, then we're going to be, this is all we're going to do. So I'd like to know, besides the argumentativeness of him, besides the rudeness, and besides him not initially complying, but then eventually complying, which we've seen in every single election, for some reason this one is different. I'd really like to know, these are typically personality conflicts. And the people that work in the polling places need to have a little thicker skin. They need to be able to deal with the public. Public is not the most friendly environment in the world. The public is often rude. They're often curt. We deal with that every day in our own lives. And that's what this was. It was a curt, it was a rude interaction. And I still don't see where the obstruction, what was she prevented from doing? I mean, the argument that I've heard so far, I guess the best argument, is she was prevented from stopping him from electioneering, which he eventually complied with anyway. And we see that every single person who's come in with electioneering, their first reaction is, no, I'm not removing this. No, I'm not turning it inside out. But eventually they comply. Sometimes they don't. We've even had people who don't comply and they leave. And they've carried their badge or their shirt the entire time. And we don't refer that to the prosecutor. This is very dangerous waters you guys are going into here. I mean, I'd like to ask Mr. Tolbert, what is the obstruction? You say it can go either way, Mr. Tolbert. What's the obstruction?
I remember based on I think it was questioning from board member Mara. She basically questioned, I can't remember whether or not it was the victim, but the question that was posed to her was, what was she doing at the time? Was she doing her job at the time? And I believe that, if I recall the testimony accurately, she indicated that it did disrupt kind of her processing other voters and being able to carry out what she was doing.
She said she was upset, but based on the evidence, she contacted the county. She made the phone calls. She did her job. She may have been flustered while doing that job, but she still continued to do it. She was not prevented or obstructed from doing that job. And if she emotionally, because of a rude interaction, she collapsed and couldn't do her job anymore, then maybe she's not cut out to do the job.
Mr. Chair.
Right. Yeah. Well, I wouldn't quite, I guess, I answered the question in terms of.
I understand.
The disruptive, she was disrupted in terms of her ability to be her job is not to, have to go and find help from the election board or call
No, that is her
deputy
job.
election.
That's her
Well,
job.
I think,
That's in the poll work. That's in the inspector training. That when
I-
situations like these of electioneering come up, that they're to contact the election board. That's exactly what that's her
I
job.
think
100%.
that,
She did it.
Hold on, Mr.
respectfully, I think we're playing a little bit of games of semantics. I think obviously her job and what we would expect our the poll workers to do is to process voters and to make sure things are being done correctly. And when you directly say, take your shirt off, and you've refused to do it, and you say, I'm the effing police, then I don't know what other evidence you can have other than disruption of allowing that person to do their job.
Mr.
So
Fett.
to me, that's the evidence. Is
Thank you,
her,
Mr.
go ahead.
Mr. Fett.
I think one of the things that's missing from part of the legal analysis is that in this case, both circumstantial and direct evidence would be considered by the prosecutor's office in evaluating whether or not to present charges for filing. And what is most troubling about what happened is not necessarily the rude interaction between Mr. Allende and Ms. Johnson, but it was the fact that he pulled out his badge when he was there as an ordinary citizen on that day to cast his vote in the 2024 general election, and that he made an effort to pull out his badge and tell her that he was the police. That in somehow, some way, that because he was a police officer, he didn't have to follow the rules. He didn't have to take off the shirt. Why else does he pull out his badge?
Probably the same reason Mr. Breezak wore a sheriff's jacket and told the woman he was going to take her outside and have her arrested, and we dismissed that.
Mr. Brezick was a deputy election commissioner, I think, at the time.
But he should have been wearing a sheriff's jacket, just like this gentleman shouldn't have been pulling out a badge. We have a
Mr. Chair.
history of dealing with these exact same things, and for some reason, we're not handling this in the same way.
Clerk Brown.
So, Mr. Chair, we're gonna go round and round. It's gonna be over, back and forth. No one's gonna be happy today because the reality of it is this thing started with Make America Great shirt and an issue about Kamala Harris, and it became too political to start with. Anyone has the right to wear what they want to. When you get into the polling place, poll workers' responsibility is to just remind you that you should not wear that while you're in there.
Cannot.
You cannot. And also, you can bring literature in and vote. How your conduct is what the real issue is here. It's not about Democrat, Republican, it's not about who president, who's not. That's meaningless. It's about what happened that particular day, that particular time between that police officer and that worker. And with that in mind, I'm making a motion to refer this to the prosecutor's office.
We have a motion, we have a second.
Second.
Second by Mr. Fetch, motion by Clerk Brown. Is there any discussion?
I have a little bit.
Mr. Reed.
I heard Mr. Tolbert say that it could be referred or not referred. It wouldn't be right or wrong either way. Coin toss kind of an issue. We've never done it before, but hey, why not start today? I guess if you're weighing all of the pluses and minuses and benefits and burdens, you've got a police officer sitting over there, 20 plus years of experience. You may like him, you may not like him, but he protects you, me, and all of us. And if we're flipping coins and deciding what to do, maybe you shouldn't refer this to the prosecutor's office. Maybe you've noticed working in municipal law and public government that finding police officers isn't much fun these days. So step whichever way you want, but watch what you wish for.
Yeah, Mr. Chairman,
Mr. Mellon.
I go back to precedent. I've been on this board for a very long time. This is being handled completely different. I've always said about this board that when we are nonpartisan, we do our best. We are a terrific and we are a fundamentally good board because we're just trying to create safe and fair elections. And I've served on this board with these individuals and other individuals who've done a fantastic job of being nonpartisan. Today, I'm seeing partisanship, and it's sad, and it disturbs me, the new direction of the board. I don't know why it's moving in this direction. Maybe there's just changes in the political wind in Lake County, but this is a travesty. Based on some of the precedents, based on some of the findings we've had in the past, based on the fact that this is an argument between two individuals, And yes, it wasn't pleasant, but there's no obstruction, please. That's, anyone who's doing that stretching, you're stretching for political reasons. So good luck to you. Vote the way you want to. I can't conclude.
Any other discussion? I guess I would just weigh in a little bit here and say that, I think as Mr. Mellon, as Mr. Reed, I know Clark Brown, we've served together for some time. I do my level best to not be partisan on this board. I try to look at the evidence as it comes at us. I think we've done a good job in the past of doing that and being fair to individuals that come before us. I would also say that, I don't want to look at this as saying like, oh, there's repercussions for someone's career, or there's repercussions for someone's, those things are, I think you have to look at those separately than what the facts are. This is a tough decision for me personally. I think it's I think as Mr. Tolbert pointed out, it's one that kind of runs down the middle. I kind of go back to the behavior in the shoot, and it's inappropriate. And I think it's somebody that's, flexing in the shoot for no reason except to get in the way of things. So that's how I feel.
Well, I look forward to future discussions.
I'm sorry, Mr. Mellon.
I look forward to the future discussions. We run into this every single election cycle. I'll bet it'll change depending on the political winds.
All right, thank you. Any other discussion? All right, hearing none, call for the vote. Roll call, please.
Yes.
Yes.
No.
No.
Yes, motion carries. All right, moving on to is there any other old business?
Dark day, fellas.
There is. Any other old business? None? All right, moving on to new business. CFA matters, James Piggy for Calumet Township Board Member. We have either Lori or Anita here. Oh, they got a form. Yes.
Good luck to you, Bill. You bet.
Good morning.
I would just show for the record that we have a quorum of 3 members present. Mr. Reed, Mr. Mellon have left the meeting.
Okay. James Piggy for Calumet Township Board Member, Mr. Piget, has passed away, and his committee had an outstanding fine of $125, and his committee has been disbanded. It's no longer functioning. We just wanted to bring that to your attention and ask the board to consider waiving those outstanding fines of $150 because they will not be paid by anyone.
Do you not think you can address this at this point in time, not 2 members left as no longer?
I don't know about that. We have quorum. Quorum generally says that if those voting members are present and you have a quorum, that can still be unanimous as long as you have a quorum. Right, but we
still have a quorum.
we have a quorum and it can be unanimous.
Voting members.
Yeah.
Voting members, yes. No problem.
All right, so the matter here is Mr. Piggy. The recommendation from Lori is to waive the fine based upon the death of Mr. Piggy. Is that correct?
Yes, sir.
All right. Motion by Mr. Fetch. Is there a second?
Second.
Second by Clerk Brown. Roll call, please.
Yes.
Yes.
No. Yes. Motion carries and is unanimous, 3 in favor, 0 against. Any other matters, CFA matters, Lori?
Yes, Mr. Chairman, we have the Cedar Lake Democratic Precinct Organization was addressed at last meeting. There was an issue whether or not they had filed their report on time, and we gave them 30 days to prove that they had. And I believe we have someone from the Cedar Lake Dems here to give an update on what they have.
All right. Yes, sir. Your name and your position with Cedar Lake Democrats.
Jeff Beal, I'm the chairman of the Cedar Lake Democrats.
All right.
Organization. After discussing with our treasurer, Tracy, she's had been ill and she's had a lot of mental and health problems. She was unable to find the confirmation sheet that she had faxed the information on January 10th. I don't know what else, we're just putting, we just asked for leniency because this was an error on her part, I believe. But she has refiled and all the information is been submitted. It's sad that it happened, but I don't think we've had any problems in the past. So we're just asking for leniency.
So Ms. Brandenburg, where does this one sit? Or maybe the staff, where does this sit, Lori?
Yeah, a $1,000 penalty was assessed by the board. And I believe that Mr. Beal is asking the board to reconsider that penalty.
All right, and the reconsideration would take it down, like if he complied, what would it be? What would it have been?
I believe
Because we don't have a situation, right, Ms. Brandenburg, where it's like a,
this is the third time late.
what you call, what am I thinking of? Where they have the ability to start up again, because it's the same office, fresh start.
No, they don't know. They didn't qualify for it, right? We talked about that.
Yep.
3 times late with the report filed now, report is filed, correct?
Correct.
And it's the letter needs to be in person, according to the community that we put out.
And how did they get to 1,000?
Because they had not filed the report at that time, and so therefore the fine was assessed at the full.
Oh, the full amount. So it could go down to 3 times with a letter, which would be to 60. All right, and, okay, we're all in agreement that that's kind of where
Correct.
we're at.
That's all we had. We're good with 60?
All right, so Carly, I'm sorry, Ms. Brandenburg, do we have to make any other motion regarding the unfairness or that whole thing?
Justice would require reduction of the previously imposed fine to the amount that the court sees.
Okay, so we need a motion, if we're going to reduce it, that we have to find that the imposition of the previous fine was unfair and unjust under the circumstances, I believe.
That would be the motion that the previous fine was unjust based on the fact that their report is in. It would then be reduced to $60.
We have to do 2 motions or just one?
One at this point.
Okay.
Yeah. Thank you. That's my motion.
I would second that one.
We have a motion and a second to reduce the fine from $1,000 to $60, given that the circumstances in which the fine was imposed are unjust and unfair under the circumstances, and the reduction would be to 60, correct?
Yes.
All right, any discussion on that motion, which is made by Clerk Brown, seconded by Matt Fetch? Hearing no discussion, roll call, please.
Mike Brown?
Yes.
Yes.
Smith?
Yes, that motion carries, and your fine is reduced to $60. Thank you, sir.
Thank you.
Anything else, Lori?
Yeah, the final item on CFA matters is we have CTE Danielle Carter, and I believe Ms. Carter is here. She also was assessed a $1,000 penalty for delinquent annual 2024 report, and she is here to address the board about consideration of reduction.
Good morning, Ms. Carter.
Hello,
Hi.
good morning.
All right, okay, go ahead. I'm sorry. Yeah.
I had lack of communication with my campaign manager as well as mishandling of my campaign information. But once I retrieved it, I proceeded to file.
Okay, so Lori, what do we show as how many times late and?
This is 2 times late, and she's here. So it was $1,000 assessed. So this would be your 2nd time late
With letter or with?
with appearance.
Okay.
Yes.
And so, do you agree with Ms. Carter's testimony before the board that she has filed and has everything in order now?
Yes, that's correct.
So entertain a motion to reduce the fine based upon the unjust and unfair circumstances. I'm sorry, unjust and unfairness of the original fine, and given the circumstances that there should be a reduction.
What's the current fine?
It's 1,000, I assume.
No, I'm talking.
Sheet 2 times late with letter or in person filed.
We have it imposed at 1,000.
Correct.
Okay, based on the last motion, this motion would be the same, except the difference would be instead of $60, this would be reduced to $20.
Second.
Any discussion on that? Hearing none, roll call, please.
Mike Brown?
Yes.
Yes.
Kevin Smith?
Yes, the motion carries 3 in favor, 0 against. It's unanimous. I should note that the last, I think we had with Cedar Lake Dems, it was also unanimous, 3 in favor, 0 against. Thank you, Ms. Carter.
Thank you.
And you can pay that fine downstairs.
Please, Judge.
All right. Next matter we have on our new business I'm sorry, Lori, anything else? All right, it's 2025 election certification. I believe that's the CEB 9. All right, we have the original before us.
Yep.
Jessica or Michelle, anything on this?
That is just certification that is required by the state and submitted electronically. There's about 3 your signature on there. As you all are aware, there were no provisional ballots cast, nor were there any emergency ballots. So when we finished up election night, that was the 100% totals. And this is just by favors of the state.
All right, do we have to approve this then?
Yes, please.
All right, motion to approve the CEB 9 election certification.
So moved.
Second.
Motion by Mr. Fetch, second by Clerk Brown. Any discussion? Hearing none, all those in favor, I'm sure this is going to be, no, this is just motion. All those in favor, signify by saying aye.
Aye.
Any opposed? That motion carries. Any other new business? Hearing none, any correspondence? Seeing none, any council report, Ms. Brandenburg? Mr. Tolbert?
The only thing I would say is I want to thank the board and Jessica and the staff for allowing me the opportunity to participate in the meeting remotely. As you all know, I don't miss really any meetings. So if I'm missing, that means that I have a really big emergency. So I really appreciate you allowing me to participate remotely. So thank you.
Thank you. And we appreciate you making the effort to participate remotely. So thank you. Purchase orders we have before us, looks like 3 POs, Jessica, is that accurate? Okay. And these are up for approval and entertain a motion to approve the purchase orders.
So moved.
Second.
Motion by Mr. Fetch, second by Clerk Brown on the purchase orders. Any discussion? Hearing none, all those in favor, signify by saying aye.
Aye.
Any opposed? The motion carries and the purchase orders are approved. Next meeting of this board is June 17th, 2025 at 10 a.m. in the Commissioner's courtroom. Is there any public comment? Any public comment? Yes, sir. If you could just, if you could, just come on up to the microphone. That way because we're now, I guess, remote or live all over. We need to be able to hear you. So if you please state your name, where you're from, and you have 3 minutes.
Jeff Rosignol, Highland, Indiana.
Good morning.
Good morning. I've got a couple of things. I'll come back to my second one, but I just want to say that I'm very familiar with Susie Barnhart and the Breezak thing, and I'm shocked, just shocked at what you fellas did today. Obviously, so is Mr. Reed and Mr. Mellon. Can't blame them for that. You know, there was no mention about Ms. Justice intimidating Mr. Alande. I noticed that. I watched the whole thing. I watched the video when it was live. Thought it was a joke, quite frankly. And no doubt, it appears there's some kind of an agenda going on here. So anyway, those are my comments about that. You may remember about a year and a half ago, we brought to you 28 people that were registered at a UPS store in Highland, Indiana as their voting address. We went to the Secretary of State. We went to the Highland PD. We went to the state police. We went to the sheriff's police and ultimately back to the Secretary of State to try to get this resolved. The update is there are 15 people still at that location registered. 3 of them voted in the 2024 election, which is illegal. And I doubt that anything will be done about that. I've got copies for you if you fellas want to take a look at them.
Have you given those to staff?
I have not. I will. I'll take care of this for whoever it is, if it's the Secretary of State or if it's you all, or if it's in the Board of Elections. I'll make some phone calls and I'll clear this up. But a year and a half, 2.5 hours we spent in a prosecutor, that was a joke. He's telling us, Ms. Parker's here, that those people are probably living in RVs. This is actually what he said to us that day. And they're using that for their address. I doubt it. But what's disappointing to me, and I think it's more on the Secretary of State, but we did bring it here. Unfortunately, we listed you as a respondent. And of course, you're not going to vote against yourself. That was made crystal clear that day. Just tell me yes, and I'll take care of this. Or if you can, tell me how we can finally get this taken care of, resolved after a year and a half, these people being illegally registered. If you can, I mean, email it, whatever, I appreciate it.
Thank you, sir. Thank you. Any other public comment? I thought I said another hand. Yes, ma'am. You could just please state your name, where you're from, and you have 3 minutes.
Yeah, my name's Carol Parker. I'm from Highland, Indiana. And I'm a poll worker since 2020, clerk, judge. And one of the things that I have complained about to the board here is that the poll workers don't wear name tags. And if they do, it says Carol or Judy, and they do not put the role that they play either. So I would ask that this board make it mandatory based on what we saw today to avoid, that's what we try to do, avoid these conflicts, that all poll workers have their full name and what their role is. And that's for the people and for them and their protection. The second thing I'd ask is that poll workers are given a direction about how to keep the cloud green, that is the internet connection to the poll pad, as opposed to yellow when we start the day. It's not clear. In Highland, we had a lot of internet connections that were not working, and it's an easy fix. And when we call the county board or the election board, we're told that it will eventually turn on, but there is a way to fix it, and the poll workers have a right to know how. The other thing is that to avoid the registration of voters to a PO box, it's a pretty simple fix that the clerk asks, not just did your address change when they're, registering voters at the poll, but that they ask, do you live at the residence still? And in that way, the person knows they have to live at the residence. If there's ignorance involved and people don't understand that they can't put a poll box down, a PO box, then why not make it clear as we're asking questions at clerks on election day by simply asking, do you still live at? And that is the address. And if it's a PO box, well, they can't say they live there. And finally, I would ask, do the rules apply, the laws on election day, the night before election day when the poll workers are setting up? Because there are people, poll workers, that think that the precinct committeeman can come in and set up the machines because the rules are different the night before on setup than they are on election day. We're asking this board to articulate that point. What is the law? Can anybody be in the polls when we're setting up poll workers before election day? And I do appreciate your time, but we poll workers do have a lot of questions. They don't always get answered, or they're answered differently. And we want articulation on those ideas. And if I could leave you with something I wish you'd publish in the newspaper with edits on the voters' voting rights and election laws that constantly get violated, should be on the front page of our newspaper. And if you could look at these and make changes as you see fit, it would really be helpful to avoid what we saw today. Thank you for your time.
Thank you. You can leave that. I'll be happy to
Okay.
make sure staff,
Yeah.
please leave that. All right, thank you. Any other public comment? Anybody else? Yes, ma'am. You could please just state your name, where you're from, and I'll start the clock after that for 3 minutes. Good morning.
Good morning. My name is Barbara Cotellis, and I'm from Hobart. My comments are about the Allende case. I wonder when was the last time any of you were poll workers? I've been a poll worker many times. We have it in our instruction, not just inspectors, but judges and clerks, that if we see someone come into the poll who is wearing attire campaigning for a candidate, that any poll worker goes up to them and says, you need to leave the polling place and come back without that. I don't think that the inspector was obstructed because telling someone to do that is part of the job. So she was doing the job. I do think that the officer was guilty of bad judgment, but that's not a crime. That's all. Thank you.
Thank you. Any other public comment? Yes, ma'am. Come on up and state your name, where you're from, and we'll start the clock for 3 minutes.
Hi, my name's Sheila Majecki. I'm from Cherville. And I just want to say how grateful I always am for our Lake County Board of Elections. And this is the first time I've been majorly disappointed. where Matt Fitch is sitting, there was someone else there last time at the April meeting, and she was kind of threatening his job, saying, oh, I hope that nothing happens to your job. She said that not once, not twice, but 3 times. So that kind of gave the atmosphere of partisanship when I was watching the YouTube. I hope everybody watches the YouTube. I'm going to tell everybody in my precinct to please watch them all, because we all have a lot to learn. We all do. I've never felt partisan before. I feel now that I'm in the middle of a Nancy Pelosi wrap-up smear. Like, we weren't getting anywhere with electioneering, so let's try this. And I'm sorry. I'm sorry that it is this way. I've never felt that way before. Even when Mr. Brown was talking one time about how he went to a meeting with Liz Cheney and everything was going to be so wonderful. I didn't take it personally. I didn't. I know he did that, but we have to not do that. We have to not be partisan. I go to work as a poll worker also, and we all work together and we do just fine. And it's always been just fine here. This is the first time I've ever felt this way. And I would like you to reconsider and come together and work together, because, you know, United States of America and Lake County, we are so good when we are united. We're nothing like this. When those 2 guys left, now it's nothing. Now it's partisan. And I think we can do better. And if you do, you'll be better if you do better. And we all can do better every single day. But this can't go. This can't go like this. We've got to do better. I think it's terrible that he wore that shirt and didn't pick up from his phone. But I also understand that he was trying not to engage by looking at his phone and not looking at her. I got that loud and clear. I don't know why y'all didn't get it, but I sure got that loud and clear. And it is terrible when people do, no matter what party. You shouldn't wear anything that is an election candidate thing when you're doing that. And it does put everybody in a strange position when you have to correct someone or put your jacket on. And 99% of the time when we find that, the person says, oh, sure, I didn't know. It's okay. Sure, put their coat on or whatever they have to do. And I think it was just a strange set of circumstances, him looking at his phone, not, you know, it was partisan. He thought she was a Harris supporter and he didn't want to get into it. I understand that, because I don't want to get into it. So he was looking at his phone and didn't look at her. I think, like Carol said, it's a huge difference when I say, hi, my name is Sheila. I am the judge at precinct 19, or whatever I'm doing that day, if I'm the clerk or the judge or whatever. And when you announce yourself to the person and say, this is why I need you to take off that shirt, it changes the dynamic right there. But saying, please take off your shirt, and yes, whatever her name badge was, that doesn't complete it for me. And I could see, I'm sad that it happened at all, but I can certainly understand how it happened. And for the sake of everybody being together and coming together, I'd like you to re-vote on that again. Look at it again. Because you are changing it a lot for me. I've loved coming to election board meetings. I've loved working. You know, I've even worked with Matt Fetch, although on what was it, the commissioners, he sends it to that other attorney all the time. He doesn't do anything, but at least he tries, right? He tried what he could do. And I don't feel that way now. I don't. And I'm very sad about it, and good luck.
Thank you.
Thank you.
Any other public comment? Last call, public comment. I just want to say on the record, I'm disappointed that our colleagues on the other side of the aisle decided it was in their best interest to walk out. That's never happened before. I'm sorry they didn't agree with the decision, but I'm hoping that they'll be back at next meeting and we can continue to try to work together for the good of the county. If there's no other public comment, I'll entertain a motion to adjourn.
So moved.
Some second.
All in favor?
Aye.
Aye. 11:24, we're adjourned. Thank you. You're gonna take that list from Joan, look into that.
Yeah, we did that.
You can get for
It's just, it's all in that.
I'm from proxy for today.